5 seconds to go. Start. The learned tribunal, in the first instance by an interim order dated 17th August 2016, directed the appellant to send him for re-medical examination. Because of non-compliance, a contempt petition was also filed by the respondent applicant, but the fact is neither the re-medical examination was conducted nor any action was further taken by the applicant in compliance of the interim order of the learned tribunal. However, the OA was finally heard and dismissed by the tribunal by an order dated 5th September 2017 on the premise that the medical report of the respondent applicant was uploaded, declaring him to be temporarily unfit on 17th June 2015, and since no efforts were made for making an application for re-medical examination within the stipulated period of 6 months, and for the first time application was filed by him on 10th March 2016, which was beyond the period of 6 months in terms of Rule 7A6 of Appendix 3 of the CSC Rules 2014, and his BMI was more than 30, and that being the factual matrix, the tribunal was of the view that it may not be possible to come to the rescue of the respondent applicant and dismiss the application. The order of the tribunal dated 5th September 2017 became the subject matter of challenge at the instance of respondent applicant by filing of a writ petition before the High Court under Articles 226 and 227 of the Constitution of India. However, there was no dispute on facts, but the High Court, on reappreciation of the material on record and taking into consideration the scheme of the CSC Rules 2014 and Rule 7A7 of Appendix 3 of the CSC Rules 2014 in particular, took note of the fact that though the medical examination report was uploaded on 17th June 2015 and the respondent applicant approached for re-medical examination for the first time on 10th March 2016 after a period of 6 months from 17th June 2015, and arrived at the conclusion that the name of the respondent applicant appeared for the first time in the consolidated reserve list on 19th January 2016 at serial number 16, and within the stipulated period of 6 months, he made a representation on 10th March 2016 for re-medical examination and took note of the word ordinarily as referred to under Rule 7A7 of Appendix 3 of the CSC Rules 2014, and held that the word ordinarily indicates that in such special cases discretion can be exercised for relaxation and granted benefit of extension to the respondent applicant. Accordingly, while setting aside the order of the tribunal dated 5th September 2017, the High Court directed the appellant to conduct re-medical examination of the respondent applicant and take further consequential steps thereafter within a period of 4 weeks under the judgment dated 6th April 2021, that became a subject matter of challenge at the instance of Union of India by filing appeal before this court. Stop.